How can I leave my farm to my son who farms with me without giving him more than his siblings?
Plan your affairs to survive to your heirs. We are Foster Estate Planning. Your family farm may not survive successfully to your family heirs without our quick 7-step farm plan review, which we offer in our initial appointment without obligation. Our solutions can help avoid taxes or destructive heir behavior so someone can actually survive on the farm. Visit online at fosterestateplanning.com. Plan your affairs to survive to your heirs. Foster Estate Planning.
I'm Michael T. Foster, and I have been licensed as an attorney since 1975, which is over 40 years. I have a Bachelor of Arts degree from St. John's University in Collegeville, Minnesota. I obtained my Juris Doctorate degree in 1974 from the University of Nebraska. I'm licensed and in good standing in Nebraska, in Iowa, Illinois, and Indiana. I graduated from Nebraska, practiced in the Nebraska-Iowa area for a couple of years, but I've been in Indiana and Illinois for over 35 years. I have also got a number of other credentials in the area of estate planning. I'm listed in Who's Who of American Law as an estate planner. I'm a chartered life underwriter. I'm a fellow of the Life Management Institute. These are all designations, probably the equivalent of a master's degree after my law degree. I am a chartered financial consultant. I authored a textbook in 1986 entitled Estate Planning. During that period of time, they came out with some rather serious IRS revisions in the way limited partnerships and limited liability companies were put together, and I had to reintegrate and rewrite that textbook because of these things in 1989. And I still use most of these principles in my planning today. I'm also a member of the Life and Health Claims Association. I am also a former member of the Chicago Estate Planning Council, the Indianapolis Life Underwriters Association, the American Bar Association. I'm a licensed member in good standing with the Indiana, Illinois, Iowa, and Nebraska State Bar Associations, and I'm listed in the National Registry for Who's Who as an estate planning attorney. According to the American Bar Association, in order to properly select an estate or elder care law attorney, they recommend several factors that the client should focus on. One is they should look for somebody who is focused in legal matters for seniors. They should look for someone who limits their practice to estate planning, long-term care, and Medicaid. And finally, they should look for someone with years of experience and take a look at what affiliations and other credentials these particular individuals have. My office has its principal place of operation in Greensburg, Indiana. This is a picture of that office. My practice is limited to estate planning since 1981. I take appointments by appointment only. I take appointments both in Illinois and Indiana. I've had clients come to me from Michigan, Ohio, and Kentucky as well, particularly farm clients. This particular slide has my 800 number as well as my fax number and my email address. Welcome to our estate planning seminar for business and for farming. Well, let's get started. The name of our presentation is Planning Your Affairs to Survive to Your Heirs. That's the tagline for my company. I'm Michael T. Foster. And I'm the owner of Foster Estate Planning and also Michael T. Foster Law Office. To get started, several months ago, I was conducting town hall meetings regarding the Syngenta corn litigation. And in the process of discussing the matters involved in that particular litigation, there was an attendee who found out I was actually an estate planning attorney. And he mentioned that he had just completed his estate plan in 2014 and that he owned 2,200 tillable acres. Well, I kind of raised my eyebrows when I heard that, and I asked him a little more. He said, well, they basically did some living trusts for my wife and I, and they put together a business entity for our farm. And when they were done, they gave us a letter saying that at the death of the last of either my wife or myself, we would owe a $16 million tax bill to the federal government in the form of federal estate taxes. I kind of whistled, raised my eyebrows, and said, not if you're my client. And that piqued their interest. So we conducted our town hall meeting, and when it was all done, they came up to me privately and said, would you take a look at my estate plan? And I did, and I found that they not only had one letter, but they had letters from 4 different Illinois law firms saying that they would have federal estate taxes in the range of $4 to $6 million after these people had put together various planning documents. The planning documents these people put together were excellent documents. The problem is they just didn't use techniques that would eliminate that kind of a liability, which to any business would be a huge liability. So as a result, I've put together a number of these presentations across mid-Illinois, and I plan on continuing to conduct them as long as people are interested in listening and using my services. The presentation is going to be broken down into 3 parts. First, I'm going to talk about how to take an estate and make it efficient. That is, get as much of the assets to the heirs with little loss to outside parties as possible. Then I'm going to talk about an estate plan to maintain the efficiency, to freeze the costs, and to keep the estate from having costs grow back. And then finally, we'll talk about an estate plan for estate liquidity and how to deal with transferring different interests and being able to have the funds to buy out different parties that are involved in a family business or a family farm. You will learn how living trust design avoids not only probate costs, but can be made to eliminate all death costs, both state and federal, and can provide for alleviation from the costs of elder care. You'll learn how to design business entities to protect assets from creditors, from Medicaid, from the IRS. You'll learn how to continue the business while treating all the heirs equally, and you'll learn how to fund the business buyouts by heirs involved in the business so they can continue successfully the business, and heirs not involved still will get a portion of their inheritance. Why are you here? Everyone wants information, but usually you're looking for some kind of information. My starting story is a classic case of what clients are looking for, and that's that they're looking for ways to make their estate more efficient, to get more of it to people they want it to go to, with little of it being lost to outside parties like taxing people and professionals. Most of you have questions about your estate plan. The handout blanks are trying to emphasize key issues. We're going to present some planning steps I've put together, and if you're confused by the end, we'll just ask questions. But after 40 years, I've come up with 7 planning steps that answered that question that client was posing to me of how can you get rid of $6 million of federal estate taxes. My 7 steps will take care of a 22,000 tillable acre farm. I can deal with estate planning issues for more simple estates without necessarily employing all 7 steps. But these are steps many planners fail to recommend. And they eliminate taxes without limits. They solve the different types of problems that clients are expecting most of their estate planning attorneys to solve. And local planners may not always understand all of these particular steps. Let's start with some basics. Your estate is your stuff. You have property, automobiles, bank accounts, stocks and bonds, brokerage accounts, life insurance. You have all these various kinds of assets, and they all have your name on it, John Doe. That consists of your stuff. It's titled in your name and your person directly. The estates of human beings in Anglo-American law and Western European law are fungible. That is, they're going to end. They're going to stop some point, and that point is when the individual named as the owner draws their last breath. When you die, your estate no longer exists. The theory of the law is that stuff at the moment of death belongs to somebody else. And we're going to go through a number of different processes to try to figure out who that stuff belongs to. 3 of them involve written titling of assets, either through a will or through titling of the asset itself, or because it's a particular type of a contract where there's equity on deposit and you can name a beneficiary. In lieu of any clear-cut design of where you want your stuff to go to as far as heirs are concerned, the default system is a probate system. And in that system, we go through a protracted court process to figure out who your stuff goes to. So that's the history of your stuff. In estate planning, we're trying to get as much of your stuff to the people that you want it to go to, that you consider to be your chosen heirs. We want to maximize that transfer, and we want to minimize the risk of loss in the way of expenses, costs, and taxes to outside parties like state and federal governments, attorneys, accountants, and the various other individuals who have to assist in getting your stuff transferred from your name to the heir's name. So we're trying to make the estate efficient, have as little cost as possible, and as much going to the desired heirs. At the same time, you want your estate to be enforceable the minute you die, so that nothing else but what you've written down will be carried out. But you also want it adjustable before you die, so that maybe the heirs that you thought were the desirable heirs prove that somehow they're undesirable, and you may want to limit or take them out. They may then change your mind again, and you may want to put them in. So you want to be able to amend and adjust this estate plan during your lifetime, but whenever you die, you want what you've got written down to be enforceable. So you want it enforceable but adjustable. And that's how we came up with the tagline for my business of Plan Your Affairs to Survive to Your Heirs. The biggest problem that any estate planner is going to have with clients is that the clients are always inclined to procrastinate. They're always inclined to put off the estate planning. At my seminars, I often begin the seminar with about a half dozen vignettes. They're all these lifetime situations of how different individuals put off doing their estate planning. There's a problem in that you can put it off too long, not only because you may pass away, but you can put it off too long to the point you become incapacitated and no longer have capacity to form or to formulate an estate plan. So it's important to take action to update your plan as soon as you identify the need to do it. Not sit and think about it, not sit and think and talk about it, because by the time you go from talk about it to make a decision, years will go by. And 65% of the American population gets caught without proper planning. So what you need to understand is that if you go through this particular presentation and you conclude you have the need for planning, you need to do something before you get out of the chair. You need to make a commitment to your family how you're going to take care of your problem. It's not our problem, but we witness all the time how people put it off, and then pretty soon something happens. They have a stroke, they have some sort of catastrophic health event, and they can't do their planning anymore, and the family's stuck. So you need to make the commitment, get out of that chair. If you need the planning, you need to do something that's going to make you complete the planning that you need to do. So the initial planning interview in my office is an attempt to learn the client intentions. I need to get a snapshot photograph in my mind of what the client has for heirs that they want their things to go to, and then what they have for things. What do they have in the way of assets? So we're going to do some information gathering in the form of information about the family and then information about their assets and liabilities. If you set up an initial interview with my office or with my staff, they'll provide you with an estate analysis, and it's 4 pages of nouns with dollar signs and then a line after them for you to kind of organize what you have for stuff and what you think your stuff is worth. And then there's also places in there to fill in who your heirs are. My initial interview usually takes about 2 hours at a minimum, and in that particular interview I will have my staff load that family information, financial information into a computer program that I have built, and then from that I'll be able to make recommendations on what I think, 1, your goals and objectives are, and 2, how to meet those with different types of planning techniques. And then finally, once we've agreed on what needs to be done, then we'll settle down on a fee. And at the end of my interview, I will usually give you a fee quote. And at the end of this particular presentation, I'm going to show you how you can sit down and have that initial interview in my office, and we can do it so that it's at no obligation. If you don't want to go forward with the plan, you won't owe me anything for that initial interview. But the purpose of the initial interview is to gain client information. In the data gathering, when we go to obtain family data, of course, the first thing we want to know is who your intended heirs are. But there's also other information we need to know about heirs. We need to know if there needs to be limits on bequests. For an example, if you have an heir who is suffering from a disability and receiving state and federal assistance, chances are that assistance is means tested. That means every so often they have to go back into the bureaucrats and explain what they have for assets and prove what they have for assets to show that they don't have too many assets and they should be paying for whatever the assistance is on their own. And usually the means thresholds are very low. They can have a $2,000 or $3,000 net worth. So you leave them any kind of inheritance and you'll disqualify them. It's important that precautions are taken to leave them their portion of the inheritance, but not leave it directly to them, so it's counted as an available resource and they lose their state and federal assistance. There's trusts that can be sub-trusts that can be put into your planning documents that will hold those assets and keep them from being assessed against the individual so as to lose their state and federal assistance. Another type of limit is sometimes their behavior. They can't handle drugs, alcohol, they can't handle marriage, sex, children, money, whatever, and you may want to put limits on things in that respect. There's also heirs that have there's family secrets. There's children born out of wedlock. There's previous marriages that have long been forgotten. Just a whole sort of things that could affect the estate at the end, and it's important that I know of that information when I'm planning the estate. And then finally, a lot of people have attempted to do their own estate planning. They didn't trust attorneys, didn't want to trust attorneys. So they've tried to use joint tenancy and beneficiary designations on different kinds of accounts to be their estate plan, and that's usually the quickest and fastest way to end up having to go through probate court, is because the designations fail, either because they're, by the time the person dies, the intentions are so contrary to what they would have wanted to do. Beneficiaries die, beneficiaries become incapacitated, beneficiaries are in severe health situations, and so it's virtually impossible to change those kinds of designations if the individual doesn't have some way of changing and keeping those things up to date themselves. Referring back to that earlier slide that dealt with those different 7 planning techniques that I've implemented, and be sure to grab a brochure if you don't have one already. It's the brochure I have available with the combines going through a wheat field on the front of the brochure. But as described in there, a lot of this particular type of farm this particular hypothetical facts will pick. This farmer would easily have living trusts, a trust for his wife, and a trust for himself. He could easily have a business entity such as an LLC that he's operating under, and he thinks he's done everything he needs to do, and he doesn't need any more estate planning. And maybe he came to the seminar just to see if he could pick up a few extra pointers. Well, the fact of the matter is, those 7 bullet points I have, 1, if you have a will, wills are totally inadequate. You need a living trust to avoid probate. If you have a living trust, you need 2 things in the living trust, especially if you have more than 500 acres of farm ground. You need to have a family health care plan. That's something every living trust ought to have in it, and most attorneys don't even touch on that subject. Second of all, if you have a living trust and you have a large number of acres, you're going to need probably a charitable subtrust in order to avoid federal estate taxes at any size estate. You need to have somebody who knows how to design and work with charitable giving. Dirty little secret about charitable giving: you don't have to give the asset to charity to make it charitably deductible. You only have to give a small percentage of its income to the charity to make the entire asset charitably deductible. Number 4, if you have a business entity, well, you might not have enough there. You may need to freeze that entity. There's ways to design that entity so the growth doesn't continually bring you back into federal estate tax liability. There's a way to freeze your equity and yet give you all the income and all the control, and somebody needs to know how to do that and introduce that. That if you have a frozen business entity like an LLC, you're going to need a buy-sell agreement. And that's an agreement where out of 3 or 4 kids, the kid that's involved in the business needs to be able to buy the kids out that are not involved in the business. And it's an agreement that's entered into now that says it becomes effective when the last of the husband and wife passes away. So that kid, they might be able to run your farm until they're 55, 60, and then you die. But at 60 years old, they're not going to be able to go to another profession, and they may not be able to survive on a third or on a fourth of your farm. They may need the whole thing, and they can't afford to have their siblings sell the farm to the guy across the road because he's got a better price. So we need a commitment for him to be able to continue working your business. And then that means that not only do we need that kind of an agreement, but we're going to need some method of funding the agreement, some way for that kid to be able to buy out his siblings and they need to have an accumulating reserve inside the business entity, and they're going to have to find the best way to fund that. And that's as important as having the agreement itself. To hypothetical family data, I've also put together some hypothetical financial information on a hypothetical estate holder, and I'm going to use this to illustrate the different concepts that I'm going to describe and how they reduce costs and expenses as far as estate taxes are concerned. We have here a farmer with about 1,370 tillable acres. We've given him some equipment, grain, and farm stuff. We've given him some mortgage on the farm, some debt. So he's got a gross estate, less some mortgage information. We basically have about a $18.2 million farm estate that we're going to take through our factual pattern, our different planning techniques, to illustrate the different savings costs that are involved. I have then taken that hypothetical financial information and projected it forward 10 years to see what the estate looks like in 10 years. So often estate planners only take a static view of the way the estate looks right now today, but they don't ever really look at where the estate's going to be in the future. So we may avoid federal estate taxes for a year or two, but the estate grows right back into those taxes within 10 years. So we're going to be looking at a two-part point list here. Sometimes the planning may look complicated for the size of the estate, but when you look at it over a 10-year projection, you see it is greatly cost-saving, achieving, and greatly helpful in achieving the goals and objectives of the particular client. The next slide that I want to explain is that of the various types of state and federal taxes that an estate is exposed to. Starting with state death tax, there is an inheritance tax and also a possible state estate tax. In the state of Illinois, Illinois has a state estate tax. In the state of Indiana, they have neither state inheritance tax or estate tax. They have no state death taxes. They've repealed them all. Illinois ranks in the top 5 states in the union for one of the highest and worst federal or state estate taxes on top of the federal estate tax, and the percentages get up into the 20 and 30 percentiles, and the exemption is only $4 million. Now that should be contrasted with federal estate tax, which is a tax imposed at death. Then the unified credit as of 2016 was $5,450,000 per person. When you have a couple, they each would have that amount, which amounts to $10,900,000. The assets in excess of that value, the estate value in excess of that amount, is taxed at a rate of 40%, which can explode very quickly. That same amount of credit is available if an individual gives assets away during their lifetime rather than waiting until death, and they use up part of that credit against the gift taxes during their lifetime. And again, that's $4,550,000 per individual, or 2 times that, or $10,900,000 for a couple. The federal estate tax represents a huge opportunity to do some planning for estates, especially for estates that are heavy with a lot of estate equity like farms, because there's a lot of things we can do with those particular types of taxes. It's important to understand that in the state of Illinois, it's very difficult to beat the Illinois state death tax as well as the federal estate tax, because Illinois only has a $4 million estate tax, but they do not have a gift tax, nor do the offset gifts during lifetime. Do they offset the credit available at death? So that adds to some advantage in trying to find ways to minimize the tax loss to the family that's built up a sizable farm estate. I have also put together a set of hypothetical facts for a small or medium-sized estate. So I've taken my hypothetical farmer, let's call him Henry and Wilma Farmer, and set aside planning for their son who runs the farm. So I've given him some hypothetical assets here. He doesn't own any farm ground, but he has a medium-sized estate of about $735,000. That's listed here. You'll see we've got an assortment of different assets assets. When the estate holder in either of these two fact patterns passes away, the one thing we need to take a look at is probate administration. This is a legal process on the county level in all states in the Union, and a petition has to be filed at the county level. And in that county court, they were requesting that the court administer the assets of the estate of the decedent. As I said, their estate consists of their stuff, and that's all the things that are listed in their name, but they no longer exist. So theoretically, those assets now belong to somebody else, and we got to go through a court process to figure out who this is. If the individual either leaves a will, that will has to go to the court process to direct the court on who to give the assets to. Or if there's no planning whatsoever, then the estate goes through the court process to determine what the assets are, who the heirs are, and what they're going to get. The probate process is the default system in getting the assets to the family members. So we just don't go from the funeral home to the family. We have to make a stop in the court to be sure that the family gets proper legal title to all of the assorted assets. Addition to a court process for administering assets at death, there's also guardianship, which is also known as living probate. This is a process when an individual becomes incapacitated for being able to properly handle their assets. The definition of incapacity is the inability to give prompt and intelligent consideration to financial matters. It's important to realize that restriction is to financial matters. It doesn't matter how delusional the individual is. If they pay their bills, they'll have capacity. And if they don't pay their bills and they're fully sane and cogent, they can be declared incapacitated. And in that case, it's the same process. Somebody will petition the local county court that the person is a resident in, and an individual is appointed as guardian to handle their assets, basically to handle their finances and to pay their bills. Once this appointment is made, the statute requires that there's a biannual hearing once every 2 years or more often if the judge feels at their discretion that's necessary. The result is you have lots of attorney fees in either situation, and it's the attorney fees that become the expense. In smaller and medium-sized estates, it's considered probate attorney fees are considered to be probably one of the largest expenses to the estate. In Indiana, they have an Indiana maximum probate fee guideline. Probate is higher for smaller estates than it is for larger estates. As the estate gets bigger, the percentage comes down. The average probate, according to the Indiana Continuing Legal Education Forum, is 6.4%. Some of the disadvantages of the probate system if you die with no planning whatsoever, that's called dying intestate. And in that situation, the state has already drafted directions to the probate judge when that petition's filed on how to hand the assets out. There are formulas that are contained in the statute. The estate must go through the probate process. The court will impose those formulas without exception. The spouse will get only part of the estate, usually 50%, and the business heirs will probably lose control of the business because it'll be equally distributed amongst all the heirs, including those not involved in the business. In-laws can easily gain rights to the family business because there's no prohibition against that. And disabled heirs will lose their assistance because they're state and federal assistance because they'll have too many assets. Addicted heirs will be at risk. They'll have the opportunity to overindulge with their new inheritance, and the taxes are going to be substantial. As we're going to illustrate here, they'll be as high as 58% of the estate. In the next slide, I have put together an illustration of what the estate costs would look like if Henry and Wilma, the large farm with $18 million, if they pass away intestate. And we assume it's all owned by Henry at his first death, and by formula, half will go to Wilma, half goes to the 4 children. And the result, as you can see on this particular slide, we've got a lot of Illinois death tax as well as federal estate tax. The overall loss here is going to be 41%, or about $7,340,000 out of a $17 million estate. And have prepared some illustrative charts on what this same estate would look like in 10 years, what these intestate costs would look like, with Henry having $30 million and leaving $15 million to Wilma. And now the estate costs, both the Illinois death taxes and the federal death taxes, go up substantially. they're up to 16 million or 53.1% of the estate. Chart of the intestacy for the son of Henry and Wilma, who is the medium-sized estate. He has a blended family. He has a spouse who was married before with children, and he has children by another marriage. And we're showing that if he dies without any planning, what will happen is his wife will get about a third or a half of the estate. Here we said it was a third. In most places by now it's a half. And his children will get the remainder. And that means that when the spouse dies, her heirs aren't his heirs. So if she just has a simple will, then part of his estate's going to go out to her heirs. And that means that if he inherits from his father a major portion of a large estate, like $17 million, then a piece of that equity is going to go to her heirs, which are totally unrelated to the farmer family. And you can see there that they do not have a lot of federal estate tax. In fact, they don't have any taxes due. What they have are probate expenses that are going to be in the range of $60,000. Now understand, these are your local friendly attorney's fees for handling and changing over the assets of this particular estate. The viewer is one of these individuals who says, well, I don't have to worry about this. I have my estate all planned and taken care of because we have a will. Well, if it's a simple will, that's usually a will of less than 5 pages, and it says that I leave everything to my spouse if I predecease my spouse. Well, here's what that looks like with a $17 million estate on this particular slide. Here we have the $17 million going to the second estate, and there's going to be some costs like probate expense, funeral expense, and so forth coming out. That's going to be pretty substantial. And then when that second estate passes, the costs are going to be outstanding. They're going to be a really true wallop. We have $5 million of federal estate taxes, $3 million of Illinois death tax, plus the local friendly attorney who wrote that simple will is going to walk away with almost $500,000 out of the estate. So you can see the combined costs are about almost $8.75 million, or 49% of the estate. The next slide takes those same numbers and advances them forward 10 years. And now we're looking at a $30 million estate that's going to end up at the second death to the spouse. We're looking at $10 million in federal estate taxes, $5 million in Illinois death taxes. That's what leaves us with a $14 million to the spouse. And then we have coming out of there $3.3 million in federal estate taxes, $3 million to the state of Illinois, not to mention $750,000 to the attorney to handle all this. The long-term result is $22 or $23 million loss out of a $30-some million estate, which is a 75% total loss. Then we look at the simple will with the son and his spouse. And if he has a simple will that directs that the contents go to the spouse, there will be no federal estate tax. There'll be probate expense to transfer it to the spouse, and that's listed here at $47,000. She will inherit the family business. The business will be exposed to second marriages. When she passes, she'll leave her assets to her children, which means that the grandchildren of the original son of Henry and Wilma, the original farm owners, will get nothing. It'll go to her kid. There'll be no federal estate tax. That's not the issue, but there will be probate expense, and the attorney's going to make about $90,000 off this deal as a result of the family losing that piece of the business out to the second spouse of the son's children. And again, these are goals and objectives that most families would probably be horrified if they knew about. You'd think they would do something about it if they're sitting and listening to the presentation and they have these fact patterns. At this point, I would assume that anybody listening to this presentation who either has no plan or a simple, 4 or 5 page will would have sense enough to make a commitment to do something. Perhaps while they're sitting in their chair, they ought to be sitting on how to do this, especially if they're looking at these kinds of expenses. The next option I want to present to you is the living trust. And living trusts avoid probate. They're intentionally designed 400 or 500 years ago to avoid the probate system. In the probate code, it says in one of the first main paragraphs of that code that the terms of the trust can be self-administered by the trustees without having to get court approval or court authorization. They can be self-administered. You simply appoint adult family members as trustees, and they can administer this thing at death, and they don't need court permission. You don't need banks, you don't need attorneys and accountants to be the trustees. You might need their advice to advise the individual family members acting as successor trustees, but you don't have to have all these authorities in there to be acting as the name of as a trustee. And that's why we have on this particular slide, the attorney fees are greatly reduced or eliminated. If you've got an attorney or an accountant in the family, well, put them in the trustee position if you feel that's a good thing to do. But if you don't have, then they might want to consult with local attorneys. We consult with people. We use living trusts all the time. It's about 99% of what we do with estates. And we can usually close an estate out in about 2 or 3 hours of time. That's why I've got listed at the bottom of this slide, everyone should consider a living trust. Unless your estate is extremely small, like less than $100,000, there's some advantage to at least considering the use of a living trust. And you need somebody who does it all the time to explain to you the advantages. If you go to an attorney who always uses a simple will or in the probate process, then they're going to talk down trusts. They're not going to know the advantages and explain the advantages, and they're going to try to talk the individual out of using a living trust. And it's the attorney fees that are the number one disadvantage of using wills in the probate process. Attorney fees are not the same. They absolutely are not the same to take the same kind of information and just simply administer it down to heirs, or to have it all in court-approved form and go through evidentiary hearings and pleadings and so on and so forth to get it transferred to the same people. It's more expensive to go through that court process. Living trusts are nothing new to estate planners. They've been around for 400 to 500 years, and every estate planner who's an attorney had to know about them to pass their bar exams. Living trusts were created centuries ago to avoid probate. They were introduced in 1545 through the Statute of Uses in Henry VIII, and they were introduced to avoid, at that time, probate was all completed by the ecclesiastical courts of the Christian Church. And as a result, he was having problems with Rome and breaking from Rome. And what he basically did is, one, he reassigned probate to the secular equity courts of England. And second of all, he set up the Statute of Uses, which was the opportunity to put assets in a trust and then exempt them from having to go through the probate process. And that history came over with England on the boat to North America and is a part of the American jurisprudence system today. A trust is not something you can see or smell or feel or hold in your hands. It's something we create on a piece of paper. And it's similar to creating a corporation on pieces of paper called articles of incorporation, and then that corporation then is capable of owning assets. Well, a trust is similar, that it's created on a piece of paper called a trust agreement, and then that trust is capable of owning property separate from the individual who set it up and separate from the designated beneficiaries. Inside the trust, you're going to have what's designated today under the Uniform Probate Code as a trust maker. In other statutes, they've been called a settlor or a grantor or a trustor. The same term at law refers to the same person. It's the trust maker, the estate holder. And then also in the document, you're going to have appointed a person in the position of trustee. In most living trust documents, this does not have to be a bank or an attorney or a CPA or a financial planner or advisor. The trustees in 99 out of 100 cases that I work with are the client and their spouse. And they would be trustees unless there's something wrong with their capacity to act in that position. They will also retain the ability to amend the document to set the terms and conditions on designated heirs to receive the documents. Heirs are going to have to meet those terms and conditions. And then what the owner does, and the reason this alleviates the whole probate process, is because all those assets that I described at the beginning of the seminar as being part of the estate holder's estate, he transfers and therefore unloads all those out of his estate into the name of the trust. He does that by retitling the assets in the name of the trust, so they're no longer part of his estate, which, as I told you at the beginning, was fungible, which has a shelf life. Instead, he puts it into a trust, and the trust has continuous life. It's an artificially devised entity to own assets. Therefore, it doesn't die when the owner dies, but continues its life well beyond the owner's existence. It'll continue to own those assets as long as there's any kind of an asset to be owned, and it'll own those assets until the heirs meet the terms and conditions that the trust maker put in it for their taking possession. They'll go to their trustee, they'll point out how they've met those terms and conditions and request title, and the trustee will be obligated to transfer to that particular heir their share of title without having to go through probate and without having to get any kind of court approval or court authority. The whole system can operate without having to go to court. If someone has a dispute, somebody doesn't follow the agreement, somebody is acting inappropriately, you can always take the whole system to a court to have it adjudicated and administered. But 99 out of 100 of these, if not 999 out of 1,000, are self-administered without any court, and the system works quite well. Some special points to emphasize about owner control with a living trust are that the owner and their spouse are always usually their trustees. There's no need to report the trust or record the trust with an outside party, such as a clerk of courts or a secretary of state, a bank, an attorney, or anybody like that. Trusts are considered private documents unless somebody publicizes them and makes them public. And that means they're protected by the rules of evidence from being divulged. And when you go to sue on the terms of the trust, you have to first obtain court permission to put the trust on corporate record so that the court can then review the terms of the document. There's no outside reporting, and they're considered a private document. Next, the living trust is usually favorable over an irrevocable trust because the trust maker retains the ability to change the directions, which gives them flexibility in the estate. They have the power to change how they want their assets to go, to redirect their trustee intent. And a lot of times there are devices that are used to try to help clarify a trust, such as a trust protector, but sometimes these can limit or change the trustee's or the family's intent, or just the family's desire to control the assets. Then last of all, it's important, one of the reasons trusts fail is all the assets don't get properly retitled in the name of the trust. This is not a difficult process. It's no more difficult than changing the title from John Doe to John Doe, trustee of the John Doe Trust, putting the words trust after the name of the owner. You can do this with car titles, deeds to real estate, bank accounts, investment accounts, stocks and bonds, just all your assets. You can make this change so that they go through the trust down to the beneficiaries without having to go through a protracted or expensive court process. In the next slide, if we use living trust for the son and his blended family, the chart illustrates what can happen. We split the assets between a trust for the wife and a trust for the husband. We would probably put the business portion that the son owns with the parents, which were Henry and Wilma Farmer, in his trust. And both can be trustees on John's on the son's trust. And then if we set up a trust for our wife Mary, both can be trustees on the wife's trust. That way both have control when the first party to the marriage dies over the assets in the two trusts. We'll make the spouse on the husband's trust to be the income beneficiary and the husband to be the income beneficiary on the wife's trust. So that way, while both the husband and the wife, both the son and his spouse are alive, the survivor will have control of the entire estate and get income from the entire estate. But by holding it in two separate trusts, we're going to guarantee that the husband's share that he inherits from his father, that is the piece of the farm, is going to go through him to his children, which are the grandchildren of Henry and Wilma Farmer. And then we'll also guarantee that the balance of the estate is when the surviving spouse passes would go to her family at her death. You'll see that we have not only no federal estate tax and no Indiana death tax, but we have no probate expense in using this approach, and consequently we've completed the son's estate plan. So those individuals with the estates that are $750 or $1 million or even up to $2 million or even $4 million, this two-trust approach will satisfy the ability to get rid of all those various outside party expenses, including state and federal taxes and probate expense in going through the court process. I apply the living trust concept to the larger estate of Henry and Wilma Farmer. These charts show what the results would be. It reduces the overall expense, but we're going to be able to do more and be more effective. We would split the estate between a trust for Henry and a trust for Wilma. We would split it reasonably equal. Both of them will be trustees on each side. Both trusts provide income to a surviving spouse. Whichever one dies first, the survivor will continue to get all the income and control the entire estate. We can see that the probate is eliminated. We also can see that the federal estate tax and the Illinois death taxes are substantially reduced, and as a result, everything transfers to the children at the second death, and we bring our expenses and costs down to 23%, or $4,127,000. I apply the living trust concept to the larger estate of Henry and Wilma Farmer. These charts show what the results would be. It reduces the overall expense, but we're going to be able to do more and be more effective. We would split the estate between a trust for Henry and a trust for Wilma. We would split it reasonably equal. Both of them will be trustees on each side. Both trusts provide income to a surviving spouse. Whichever one dies first, the survivor will continue to get all the income and control the entire estate. We can see that the probate is eliminated. We also can see that the federal estate tax and the Illinois death taxes are substantially reduced, and as a result, everything transfers to the children at the second death, and we bring our expenses and costs down to 23%, or $4,127,000. When we look at the future, 10 years future for the Henry and Wilma estate, if they have just a living trust and there's been no more planning, we can see on this next slide that the estate costs start to go up. We still have no probate, but the federal estate tax and the Illinois death taxes all start to become rather substantial, to the point that there's about a $13 million loss, or 43% loss, before the assets reach the heirs. So we want to keep planning with respect to this couple. In speaking with my initial case, when I told you the story at the start of the presentation, this is how far that couple had gone with planning. This is what typical attorneys, most attorneys, can do as far as estate planning is concerned. They'll be able to use effectively the $5.45 million per individual effectively. But when it gets to trying to beat federal estate taxes above and beyond the $10.9 million amount, they start to fall short, and we need to do additional planning. And so now we're going to look at some of these techniques that can be employed. So if you have a living trust and you're sitting there in your chair and you think that's adequate, but you've got more than 500 acres that you own, I've got news for you. That's not adequate, and there's more planning that can be done. And let me show you what that looks like. Let me introduce to you with this next slide the concept of charitable giving and estate plan. A dirty little secret about charitable giving is that we can set up charitable subtrusts within the living trust, and we can put assets that are not covered by the unified credit amounts of $5.45 million. We can take that excess and hold it in a charitable subtrust, and the whole thing will become estate tax deductible if we give just a small portion of the annual income off those assets to a charity. Right now, the rate of interest off that's about 2% that we would have to give. The rest of the interest, the rest of the earnings off that amount can either be accumulated within the subtrust and passed on to heirs after 22, 23 years, or we can distribute that income annually. And I've got some charts here that'll show you what that's going to look like. But we take the excess, the portion that's not covered by the unified credits, exemptions, and deductions available to the estate, and we're going to put them in a subtrust that makes them an additional part of deduction, so the IRS gets nothing out of the estate. The next slide actually demonstrates how this charitable subtrust portion would work. We're showing here that an excess portion out of the Henry and Wilma estate of about 3.4 million, a little less than 3.4 million, is being put into a charitable subtrust. It'll provide an annuity of about 199, just a little short of $200,000 a year to any one of designated charities, and there'll be a pre-tax income distribution of about $175,000. If that's allowed to redistribute back to the heirs, assuming a 35% tax bracket, we show how at the end of that time period, the money that's left in is the same $3,400,000 we started with, and it recycles back to the family after 22 years like a second type of inheritance. This next slide just simply shows what happens to the 20-year to the 10-year future estate if we use this same concept. Now we're setting aside $10 million. It's producing a little less than $600,000 a year, but it's also generating another $516,000 a year, which could be distributed out to the family. This is using an 11% rate of return. If you're wondering how we get 11% rate of return, you need to talk to the financial advisor. To talk to my office, we work with a financial advisor, and he does this with some fairly routine debt type of instruments that we can advise you about. The next slide illustrates the application of this charitable giving subtrust to our case of Henry and Wilma Farmer. You see here what we've done is when each one dies, the excess is held in the charitable lead annuity trust, and that's about $3,052,000, and that's going to provide income to the charities for 22 years, and then that amount, that $3,052,000, comes back out when the second party dies. 22 years after that, after the second death, that comes back to the heirs as a second inheritance. And you see that happens both with Wilma's trust and with Henry's trust. The result is federal estate tax goes away, and we're now down to Illinois death tax. Illinois death tax doesn't get wiped out because, one, they don't have a charitable deduction, and two, they don't have as much unified credit, and we still have a funeral expense. All right, the only way we're going to get rid of Illinois death taxes is we're going to have to do some gifting during the life of Henry and Wilma, and we'll talk about that here in a second. But you see, we've reduced our cost down to $755,000. We've saved just a little under $8 million in death costs, and we're now down to 4.44% cost to this particular estate. The next slide is just enhancing the assets with 10 years of appreciation. So now we've got $15 million estates apiece being divided in half. We're using the same process 10 years later, and you can see that we now are down to $755,000 of expense. We still have the Illinois inheritance taxes left, and it's about a 2.5% cost left to the entire state with a $22 million savings. We're still moving in the right direction, but we can do a little better. We can get rid of the Illinois death taxes with just a little more planning. Now, if you're in the point where you have a living trust, but nobody's ever talked to you about this, instead they gave you a letter saying you owe $3 million or $5 million or $2 million or $8 million, whatever, of federal estate taxes when you and your spouse dies, then you need to do some planning. Don't just sit in your chair and think that you've got it okay and you don't need to look at anything and you're just getting tips. You might need to actually step forward, make an appointment. It's your stuff, not mine. It's your $8 million you're losing, not mine, and actually make an appointment to review this stuff and see if your stuff shouldn't be updated and see if you can't somehow incur these same savings. I can guarantee you my planning costs, much to my chagrin, aren't going to cost you the millions of dollars you're going to save. Some disadvantageous considerations to using a charitable subtrust. One is we would like to make the contributions smaller. The annuity strain, it could be a strain on cash flow, and it's possible we want the lowest amount of annuity flow possible. That means in the Internal Revenue Code has a chart. And the lower the annuity, the longer the period of years it has to be paid out. And 2% usually requires about a 22-year period. You may want to accumulate the excess income in a reserve. You may want to pay it out to the heirs. And then it's also possible, if you don't like large contributions, to prepay the annuity out of the assets so you don't have the annuity around anymore. These are just some additional options. Sometimes people don't like the length of time that the annuity has to persist. There's not much we can do about that other than paying more out over a shorter period of time. Concepts that I want to add to our planning discussion are ways to maintain the estate efficiency. We get the estate down as much as possible while the client's there using living trusts and charitable subtrusts. How do we keep it down? How do we keep the taxes from constantly growing back? We don't want to stop the appreciation and growth on the asset, but we like to stop the taxes that result. And so we're going to talk here about asset protection, protecting the assets from creditors. We're going to look at freezing the taxable equity and gifting that equity, and then we're going to look at ways to transfer the remaining equity at death. We're going to look at some of these different concepts as they fit together. Concept I want to talk about is asset protection, and what that usually means is putting business and its assets into a particular type of business entity so that personal judgments, like for auto accidents or something, can take your farm away. And so by putting it in a business entity, it's protected from those kinds of judgments. And likewise, if the business screws up and you somehow lose major portion of assets in business, you don't want to also lose your personal savings. Is there a way to avoid losing everything in a single lawsuit by a creditor? And my response is, first of all, I am a big believer in limited liability companies. Limited liability companies, or LLCs, have more asset protection than do corporations or family limited partnerships. The manager's liability in a limited liability company is limited to just what they have invested. So if they paid $1,000 for a managing member share, their loss is that $1,000. That's not always the case with a limited partnership. If the general managers are going to be fully exposed to the liability of a family limited partnership, they're fully exposed to the extent of their personal assets as well as what they've invested. There are when it comes to corporations, they're only allowed one class of shares, and you can levy on those shares if you have a debtor who owes you money on a judgment, and they own a sub-S corporation. You can levy on their sub-S stock. There's a court procedure to have that stock signed over to you, and you then take over their corporation. You can't do that with an LLC because each member is considered a fiduciary to the other members, and a creditor can't force themselves on a fiduciary on other individuals who have an investment at risk. That's a level of protection that corporations and sub-S's don't provide. And sub-S corporations, accountants to me seem to be addicted to sub-S corporations. They'll recommend them just because they think they're better to work with because they're more familiar with them. But fact of the matter is they don't have as much asset protection, and they do not allow for different kinds of shares. They only allow one class of share, and one of the critical elements in estate planning is we have to be able to separate growth in order to freeze the value in the parents' hands. And we can't do that because the sub-S tax laws don't allow for that. And last of all, we want shares beyond levy of personal creditors, and an LLC provides us that protection. So for that reason, I'm almost always exclusively using an LLC or limited liability company as the form of business entity in which I want Henry and Wilma to put their farm. The next concept I need to explain to you is that of gifting. And that means we're going to transfer appreciating assets as going business farms and going business concerns. In gifting, we're allowed to transfer right now $14,000 per donor or per donee per year. And that means that a husband can give $14,000 to his son and $14,000 to the son's spouse, and a wife can give $14,000 to the son and $14,000 to the son's spouse. So from parental couple to child couple, we can transfer $56,000. Well, the way we would use that is we're going to want to use that on appreciating assets like land, not on cash and bank accounts and other smaller assets. Land is what has had, from 2007 to 2013, it had 17% growth per year. So the farmland of Hank and Wilma are the items we would like to somehow freeze and transfer. But they need all that land. They have to farm all that land in order to survive. And so first of all, we never include in-laws in our family planning. I will withdraw before I will include in-laws. We only include blood relation parents and their children. And in fact, we have spouses agree to a spousal disclaimer. And I've had lots of spouses not like that. They wanted to run the family farm, but we've either excluded them or they excluded me, because I've seen too many bloody situations in divorce where we just can't tolerate the results. But basically, those are the items that work. We want to transfer the growing appreciated assets, and by putting them in a business entity, we're going to turn them into shares, and then we'll create different kinds of shares so that we can modulate what kind of growth goes to the parents, what kind of income goes to the parents, and what kind of growth and income goes to the children. Next slide is a simple graph of what's going to happen to any business in order for the business to continue its existence, whether it's Hank and Wilma's farm or whether it's a retail store in the city. The red line shows that over a 15 to 20 year period, the business has to grow or it'll die. It has to have growth. It has growth in its total equity. However, when we do estate planning, too often planners are looking at just the green line, not the red line, and that means they're looking at the growth being level. And actually, I'm going to explain the blue line here in a second. But what we need to do is find a way to keep the portion that the parents own frozen and at a level value that stays underneath those unified credit amounts on federal estate tax. And the way we're going to do that is by having different shares that separate that growth and give it to the younger lives or the children, which we'll show you in the next slide. This graph shows that in order to freeze the equity of the parents, we've got, again, the red line is the business value, and the owner needs to be on the green line, which is a frozen line. And the way we would do that is to transfer the growth so the parent's equity stays level. And the way that's achieved is we create three kinds of shares. In a normal entity, you would have just one type of share. Let's say a typical sub-S corporation has 100 shares. That means each share has 1% of the voting, 1% of the income, and 1% of the growth. And you divide that up. Most partnerships, a lot of accountants aren't used to my kind of entity, and they're used to partnerships where that income growth and voting is divided out by certain percentages to certain partners. What I'm going to do in my limited liability company is I'm going to unbundle those rights within a single share, and I'm going to create shares that are just voting from shares that are just receiving income from shares that just have growth. And the parents are going to give the growth to the children, and they're going to keep a preferred dividend to income. They're going to keep the right of income. And that puts them on the green line, on a level line, and levels off their particular estate equity at their death. Now, as soon as you separate income from growth, there's an Internal Revenue Provision Code section 2701A, and it says that any time you're going to divide income away as a life, and give that share as a separate share, that particular code section is going to be triggered, and they're going to have a very special formula in how the parents' shares of lifetime income are valued. It won't be a calculation based on the remaining stated value in the entity. It's going to be a value based upon the amount of guaranteed income times the parents' remaining lifetime mortality based on federal tables of mortality. Next slide illustrates over time what happens when we separate these three kinds of interests. We see that the growth continues in the children. That growth interest under Section 2701AA is going to be treated as a gift to those children. When we will have a gift tax, and it's going to be equal to the value of the growth right. The value of the total entity is the value of the growth right, and the income right of the parents is going to be determined by a guaranteed dividend stated in the document for their lifetime. Now, that guaranteed dividend, current regulations are setting that at about 2 to 2.2% at the time of this particular recording, and that is starting to rise. That means 2% of the equity has to go to the parents for on an annual basis. And the first thing I want to ask parents is, do their costs of putting in and harvesting a crop, does the cost of operation exceed that 2%? Most of them will laugh because it's multiple times the 2% amount to put a crop in and take a crop out. The operating agreement I use allocates all costs and expenses to these Class A income interests, and it also allocates what's called an annual preferred dividend to this Class A account. And so the expenses and the qualified dividend are usually a wash. In other words, if they pay their bills, they will have satisfied the requirement for a preferred dividend. As they age, their value of their interest, their Class A share, is the number of qualified preferred dividends times the number of years they have remaining. So if it's a 2% times a life expectancy of 20-some years, it'll come out with a substantial discount in the value to the parents as opposed to the value that was transferred in Class B growth shares to the children. And that difference is what we file a gift tax return on. The parents' interest as an income interest is not only frozen, but as they go through their life expectancy, the multiple of years gets shorter and shorter, and it actually is the green line on the graph. It actually declines at an average rate of about 2.7% a year. And so the result is the parents' interest is frozen, and then we file a gift tax return documenting all these numbers. And that return, the IRS has 3 years to review, pick it apart, and tell me my math is all goofed up, or they're stuck with the numbers after a 3-year statute of limitations runs from the date of filing. So we like to file those returns. We always use up a good chunk of the unified credit amount, but we never have any actual taxes due on the return. We use it to use the unified credit up to freeze the estate. And this usually will allow me to freeze an estate up to $25, $30, $40, $35 million and be able to freeze that estate so there's no federal estate taxes. And then we combine that with the charitable subtrust concept so that if there is any taxes, it'll be offset and deducted by a charitable deduction for a charitable annuity going to the respective charities. So the long and the short of it is it eliminates a lot of the equity problems that the owner has. Gift tax return is Form 709. It has to be filed in the first quarter following the year of the gift. As I said, Unified Credit usually wipes out any actual tax. We use that credit up, but we also freeze the estate, so we're not as concerned about credit in the future. Credit may be used during life or at death. That's part of the provisions of the code. And again, 4.5 million, 5.45 million per estate, or 10.9 million per couple. If we add this concept to Henry and Wilma's estate plan along with the charitable giving, what we're going to end up doing is the amount that we transfer to the children is going to greatly reduce their estate. They still have an excess that could possibly be held in the charitable trust, the charitable subtrust, which will eliminate taxes. But by freezing and gifting away the assets, we are going to not only reduce federal estate taxes, but we're going to eliminate Illinois taxes, because Illinois does not require a gift tax, nor do they have an adjustment for use of gifts during lifetime on their estate tax. And so the result is that the estate is going to be considerably smaller, and we will have eliminated the Illinois taxes. You can see here how we've put all this together, and then we have shares that will belong to the children. In this next slide, we've actually looked at the numbers that result from using a frozen LLC to own Henry and Wilma's farm. We see we have a gross estate at the two deaths in the existing estate of about 8.850. Our only costs are going to be their funeral costs. We've eliminated now finally the Illinois death taxes, as well as probate and federal estate taxes. We still have a little bit of a gift at the second death. We are down to 0.16, almost 17%. 17 basis points is our loss, which is starting to look more and more like a funeral cost. You can see we've greatly reduced it on current expenses. This next slide is a projection of the estate, and it just further reflects the even greater percentage of savings, and now our costs are reduced down to about 0.09%, which is essentially 1 basis point of a percent of the total estate from where we started initially. What we've done here, and the way we've gotten this down, is not just by charitable giving. Actually, we've reduced the charitable giving down to the smallest number possible. We were able to achieve this kind of a savings by including all the 4 children in the estate as part of the LLC, and then setting up this separation of income from growth. And because of the IRS formula that's imposed on that type of an arrangement, we greatly reduce the amount of taxable equity that's includable in the parent's estate. That leads us then to the next question of, some children are involved in farming and some are not, and how will we handle that particular arrangement? Planning techniques lead us to some business continuation questions. The first question is, can the son who's doing the farming survive on just 25% of the farm? Usually they cannot. They'll find it to be a real financial strain. The other 75% will require that an amount of money out of every harvest, similar to cash rent, would go out to the siblings. That cash rent to the siblings will affect profitability, and it'll feel like an unending mortgage, because it is an unending mortgage. And so that farming heir, if they can't survive, will have to start over, usually at 55 or 60 when their parents pass away, unless there's some arrangement in which they can buy out the siblings who are not involved in the farming operation. Is left to heirs that are involved in the business, and to heirs that are not involved in the business. Conflict is usually the norm that will result. It results because the involved heirs have objectives diametrically opposite of the ones that are not involved. The farming heirs want to keep the farm together, while the non-involved heirs, if the farming heirs can't come up with a high enough price and can go across the road and sell the ground to the neighbor. The farming heirs are stuck in the business. Once they get to 50, they have no other option, whereas the non-involved heirs are not. They can take money at any point, so it doesn't matter to them how successful, how profitable, or how long the family keeps the farm. The farming heirs want to constantly reinvest the excess profits into making the fields more productive, into more productive equipment. The non-farm heirs are constantly looking for the highest and maximum amount of return from their investment in a part of the farm. Finally, the farm heirs want to buy out siblings at the lowest price, and the non-involved heirs want to sell for the highest price. Unresolved disputes in these types of situations are the norm, and I have cases where these disputes have gone on for 2 and 3 and 4 generations. If the answer to these questions is unfavorable, then what needs to be implemented is a exit agreement as for the husband and the wife, for Henry and for Wilma, and that will usually consist of a buy-sell agreement between the siblings, between the farming heirs and the non-farming heirs, where the non-farming heirs as sellers commit to sell their interest in the farm operation to the buyers, which are the farming heirs. It'll fix a price within limits. The problem is that price has to be reset every so often because farm ground tends to constantly appreciate, and if that price gets out of date perhaps more than a year or two, we have to reset the price or have some sort of way of dealing with the appreciation on the farm ground built into the buy-sell agreement that we put together. We also need the buyer's right of first refusal. If the seller wants to sell the ground to somebody else, they need to commit to providing the sale to the buyer if the buyer matches the outside purchaser's price. That keeps the control of the business in the family and within the hands of the farming heirs. And it'll also help resolve the parental dilemma. Everybody knows what the expectations are at death. That's all been said ahead of time, and there are no surprises. The one necessary ingredient to a buy-sell agreement is there must be some sort of funding or reserve set up to actually execute that buyout, or it just becomes meaningless words. We have looked at the various plans for maintaining efficiency or obtaining efficiency in the estate plan, and for maintaining that efficiency, keeping the estate taxes and the other expenses and costs reduced. Now we're down to the point where we need to come up with a reserve for whatever expenses are left for such things as perhaps taxes, perhaps being sure we have charitable bequests properly funded, or last of all for buyout between siblings to the estate. There are 3 types of capital that are available that we're going to look at. One is the use of existing capital. We'll talk about the complications with that. And then the use of borrowed capital, which is going to be our most expensive alternative. And finally, the use of created capital. One of the options in trying to come up with capital at the time of death is to try to use existing capital. This is usually when we're looking at trying to pay taxes of one type or another. The problem with the estate when the estate holder dies is that we're usually desperate for cash, and one of the first places the Internal Revenue Service will go to get their taxes paid is they will drain all the bank accounts or the most liquid assets first, and then they'll move on to the semi-liquid assets. It will take 9 to 15 months from the time of death that we have to come up with this kind of money. 9 months are when federal estate taxes are due, and you can get an extension for an additional 6 months. So 15 months we need to have a check for hundreds of thousands, if not millions of dollars, go through the bank account without bouncing, or the bounce is a felony. That means that a lot of times we have to quickly sell assets, which means we're going to have to put them up at auction. That means that sometimes instead of waiting for that right buyer and the right price, we have to sell it quickly for whatever buyer comes along. and we may incur the statistic is as much as 1/3% of loss for of value. So that means that we have to sell $150,000 worth of assets at $100,000 cash to come up with $100,000 cash. Next slide illustrates this concept of the IRS taking the most liquid assets and then proceeding down to the least liquid assets, which are the real estate. And then here we have the husband's first. The husband dies first, and then the wife dies, and we can see the assets listed in order of liquidity, with life insurance being first. Now that depends upon who's the owner or who's the beneficiary of the life insurance proceeds. If those proceeds are payable to children or a spouse, they may not be available to the estate. Then we go through the bank accounts. Then we would go through intangible assets, which would be things like stocks, bonds, mutual funds, retirement plans. Somewhere in there would be stored grain, which is considered an intangible. It's a commodity. Those are all liquid assets we would go through first. Then we would go through the tangible property, the business assets. The last thing we would go through is the real estate. So the effect is to suck all of the liquidity, all of the ability to operate out of the core of the business. So all we're left with is land and no means to make that land productive. You can see at the bottom that we're selling about $3.25 million worth of assets to pay about $2.9 million worth of debt. That's $1.10 for every dollar that's owed. The next liquidity alternative to consider is borrowing capital. The problem is that you just don't repay the principal, but you have to pay interest, and interest is incurred and paid on the entire debt, and that's outstanding, and then as that debt's reduced, the interest will get smaller. There are government provisions for borrowing, but they're limited to about $500,000 that can be borrowed. Those are under Section 6166 and 6166A. These provisions greatly restrict the ability of a business such as a farm, because there's a lot of frequent audits, very detailed audits, to be sure that the government's getting their share off of the sale of livestock or grain before anybody else gets their interest. And then finally, there's just the sheer cost of interest payments on loans. If a person has to pay back a 3% rate of interest on a loan over a 10-year period, they're going to pay $1.83 for every dollar that they borrowed. If they have to pay back 10% interest, they're going to pay back $2.53 for every dollar that they borrowed. And that makes borrowing money to pay either other siblings for a buyout or to pay the government for taxes the most expensive alternative that there is. Next slide demonstrates this cost in borrowing. We're looking to borrow $2.9 million of death costs, and we ended up actually paying back to a commercial lender, because their interest rates are going to be much higher, $4.8 million in interest on a, let's see here, we have a $4.1 million loan, and we're paying 4.8 back. We're paying 4.1 to 4.8 back for costs of 2.9, which is $1.40 to $1.64 for each dollar owned. And as you can see, that's a lot more expensive. But if you don't use any other option or do any other planning, this is the result that the farming heirs are going to be left with. It'll be their only option. It's either this or don't buy out the siblings. The next option that we want to analyze in coming up with capital or liquidity is what I call created capital, and this is basically the use of life insurance death benefit, creating additional liquidity when the liquidity of the estate is short. The advantages of life insurance is instead of coming up with the basic amount we need at death and then having to pay life insurance on top of that after the death, we're going to have to prepay the amount before death. And by prepaying, we're just paying premiums in. The premiums are going to collect in a cash value fund or reserve fund, and they'll have earnings and interest on top of that. The result is we don't need the full 100 cents on the dollar for the amount that has to be developed for liquidity. We only put in a small percentage of that dollar, less than the dollar, and the interest earnings will carry the cash reserve up to that amount by the time of death. At age 40, a person would pay 5 cents total in premiums for every dollar of death benefit they get back. The other 95% difference is the total compounded interest from the time we start paying until the time that the death benefit is going to be owed. If we incur it on an insured who's age 60 instead of age 40, we would pay 25 cents total premium for each dollar of death benefit that we get back. And thus, this is going to make life insurance the cheapest alternative in attempting to come up with any dollar figure that we've predetermined to be necessary at the time of death. In order to properly set up the life insurance so it solves the liquidity issue without increasing the need for liquidity by adding taxes, we have to look at the characteristics of life insurance as it's taxed in an estate for estate and gift tax. If we have a large policy on the life of Henry Farmer, if Henry is the insured, the owner, and Wilma's the beneficiary, the death benefit's going to go to Wilma, but because Henry's the owner, it'll be includable in his federal estate taxes, the death benefit in his taxes, for calculating how much his federal estate tax is going to be. But the money actually is in the estate of Wilma's estate, where if she uses it frugally, it'll be there when she dies and included in a second tax for the calculation of estate taxes on Wilma's estate. The three positions that need to be analyzed is who's the insured, who's the owner, and who's the beneficiary. When it comes to gift taxes, if these three are all different, we're going to have a taxable gift of that death benefit when the insured dies. For instance, if the insured is Henry and the owner is the wife Wilma, but the beneficiaries are the children, the IRS, the Internal Revenue Code, says the owner wife paid premiums and made a gift of that death benefit proceed to the children at the death of Henry, and there would be a gift tax owed by those beneficiaries on that life insurance death benefit. Anytime we have three on a match, we're going to have a problem with a gift tax. So those are the basic rules of looking at those particular types of designations on the. If we are considering large amounts of insurance, such as multi-million-dollar amounts, then there are two different options in order to make that death benefit not includable in the calculation of federal estate tax for either of the two parents. This slide is discussing one of those options, which is the irrevocable life insurance trust. In this case, the insured would be Henry Farmer, but the owner and beneficiary is an insurance trust. This trust must be irrevocable, and the beneficiary of that trust are the trust is the estate heirs, that is the children of Henry and Wilma. It also will provide that the spouse, if she survives Henry, will be the income beneficiary for life, and it'll include her as a co-trustee as long as the benefits of the trust are cash proceeds, and she will not be a co-trustee on the life insurance, but upon the death of the insured, she can become a co-trustee. She has to have some limits in that position, but she'll become co-trustee. The result is there will be no estate or gift taxes on that death benefit. Neither Henry nor Wilma will be considered to own the insurance, but again, the trust must be irrevocable. And one of the problems with irrevocability is it can be very cumbersome to work with. The cash value is inaccessible. Very difficult to access cash value and use it during the lifetime of Henry if any particular liquidity crisis comes along. There are gift tax consequences. There's limits on the amount of premiums that are paid into the policy, and it's not unusual in trying to set up a buy-sell agreement on a farm to exceed that the large amounts of insurance are needed for the buyout, and therefore the premiums exceed those gift tax limits. Irrevocable trusts I have found to be very inflexible. when later changes come along, either in the family or in the buyout process, or in the need to change the insurance, the irrevocability can be very cumbersome to the entire plan. A second option that's much more favorable when it comes to establishing large amounts of insurance for liquidity needs at death of the estate holder is the 2701A 3-tiered LLC we just got through talking about. If we've set one of those up, they are an excellent vehicle for owning the life insurance and giving us enough flexibility that we can use that cash value for other financial crises that might come along, and being able to manipulate that without the death benefit increasing the estate costs to either of the parents, to Henry or Wilma Farmer. Henry and Wilma's tax values remain frozen values. We're just taking the return from that and directing it back into an investment known as life insurance, and as a result, their particular equity does not appreciate. The death proceeds only increase the heirs' growth share at death. The proceeds of life insurance into the entity are used to redeem the non-involved heirs' shares. In other words, the $1 million goes out to the non-involved heir, and the heir's $1 million of shares come back to the entity. So only involved heirs' shares are outstanding in involved heirs' hands, and they remain in control. The death proceeds also add to the heirs' basis in the LLC. So as a result, we don't have any capital gain issue by adding the death benefit. Business heirs are then the only remaining shareholders, but the policy cash value is accessible for disability or retirement, and it gives us a whole lot more flexibility. The policy management is amendable to tax law changes and to family changes as they come along. If you had to admit on this last slide that you need to revise your estate plan, then I'm going to kind of put it to you. What does it take to get you to commit to do that? What does it take to get you to move? How many seminars, how many books, how much Googling, how much research do you have to do before you actually sit down and get something done? It's your family's plan. If you die with it unprepared and you don't do the planning, whether you do it with me or somebody else, it doesn't hurt or affect me at all. It's your family's problem. It's your estate that gets lost or doesn't go the way you want it to. So you're the one that needs it. So why put it off? We have a lot of frustration with this, and understanding people get to this point and finally admit they do the planning. So why put it off till tomorrow? Why not make a commitment to at least sit down with somebody to at least consider beginning to do the planning? It is a huge issue, and it blows my mind why people would keep putting it off. As an incentive to the viewer in watching this video, we're asking that if you immediately call or let us know that you want to make an appointment to just investigate your estate planning need, make that initial appointment we discussed earlier in the presentation. What we're going to do is offer you free consultation time. Because you listened to the seminar, we want to make your initial appointment available to you at no obligation. You can hear us make recommendations, and if you don't want to do anything on it, you don't have to pay us anything for the video. Schedule right away, and we will give you that initial appointment. We'll give you an initial consultation fee waiver for 2 hours of consultation time at no cost, and if we go over that amount of time, we're not going to charge you anything extra, and we'll also guarantee you that in writing in that same waiver form. But you need to contact our office and make an appointment. We usually request that you do that within 14 days of hearing this or receiving this video, or as soon as possible. Sometimes our schedule doesn't allow us to do it as quick as we'd like to. But if you call in our prompt, we will give you this initial free consultation time. I'm able to offer this initial meeting time at no obligation. You've got nothing at risk to check us out, to ask us your questions, your specific questions about different aspects of your estate, and get your answers privately and personally and directly. So you'll know how to proceed, and you don't necessarily have to pay us anything to get those particular answers. So again, consider making an appointment. Finally, if you have any questions about what you've seen in this DVD, you can contact us. The best way to contact me is by email, and I will write out an answer and send it back to you. But you can call us, you can email us, you can fax questions in, and we'll try to get a response back to us. Like I said, the easiest, most convenient way to answer you is to send me an email. That's Mike at FosterEstatePlanning.com. Our phone number is 855-524-2606, and our fax is 866-524-6062. So we would encourage you to contact us, and most important of all, if you need that planning, you identified it in your evaluation, call and get an appointment to at least pick our brains, get our 2 cents of what you think you ought to do. Maybe you'll want us to do it. If you want somebody else to do it, you'll at least have our notes to compare to what they're recommending. Yeah, but the important thing for you is to get it done, and get it done as soon as you have the recognized need, because there's all sorts of stories out there, people who needed to do the planning, and before they got home, catastrophic events happen, and they've lost their ability to do their planning. So be prompt and don't procrastinate.